All right, Bill Hantario again, Constitutional Coop Headquarters. At the start of a new month, and a lot of good things have been going on. I mean, so much in the last 6 weeks alone. And it's my job to teach you listeners out there how to go into even their corrupt courts, aka administrative tribunals, and win your case. And by golly, in most cases, you can do it. I've never had a loss as such at any time, especially in traffic courts. It's embarrassing there because even if you get quote unquote convicted, I've never been sent to jail as a result of any such conviction. And then they want to fine you. And they do that, and you go in there like I did in years past and demand them to define dollar, which they can't do. They can't prosecute you for a willful failure to pay a fine, can they? And that's just the beginning of the money issue that affects everything we do: jurisdiction and venue, undefined dollars. And with that being the case, then you look and see how we got to these undefined dollars. That comes under the New Deal and FDR and the bank holiday of 1933, where he invoked emergency powers under the Federal Reserve Act, which doesn't exist, by the way, and more revealingly, the non-existent Trading with the Enemy Act of 1917. That's what they think we all are: undocumented enemy aliens. And this is why we can beat the bastards in their own courts, and or better yet, set an unopposed record in that quote unquote trial court that we can come back with and bite them in the ass later with a petition for redress of grievance, almost certainly without even filing anything that looks like a civil rights complaint. Doesn't exist, by the way. The 14th Amendment doesn't exist. There's no way that civil rights exist because they're intimately linked. And that was the plan of the New York banksters back in 1868 to do exactly everything they did, make it look good on paper, like this government is very good at doing. But you get down to the trenches and find out what's really going on. It's egregiously ugly. We've had a martial law government now for in effect 160 years, maybe going back a little further than that. I won't nitpick about Lincoln and the Lever Code for right now, but that's what we've had. No judicial courts anywhere in sight, which is what you instinctively know that you should have. And not only that, but a right to trial by jury, the foundation of the English common law upon which our American jurisprudence was based. And yet you go in there and try to demand a trial by jury and see how far you get. And in the event you actually get one or want what looks like one, it won't be, because there's no qualified members of the juror pool, and you'll be making those objections like this. When you get my modestly priced constitutional defense document packets, send me an email, youwinnincourt@gmail.com. I'll get you out information on what I do. You're going to love it. And it's great not only for you, but you can then use my materials to teach your children and your posterity to keep them out of harm's way to the maximum practicable extent. That's how good this is, and why in my 74th year, life is still ahead of me. That's amazing when you think about it, but it is, and it's the energy I have, and I was put here to do this. I happen to have the abilities, and it's a lot more than memorization, names, dates, and places. You have to get the perspective. That's my job, to teach you that, and I didn't get it right away either. It took a long time. I spent 10,000 hours in those musty old stacks of law books back in the day when I could get into UC Berkeley and Hastings College, which I can't today for a variety of reasons. Thank goodness we have the internet, and I'm a pretty good researcher anyway. But that said, all of that's paid off, and I'm so good at what I do, if I say so myself. They won't let me anywhere near a jury. I'm never going to see one, at least in my own cases, and probably not in yours either, because I come in there as an expert witness, which I am, and I have a boatload of proof to sustain my claims. And no, I've never been to a law school, never been brainwashed by one either. And this is where we get the bastards, and we set an unopposed record and we can come back and make them pay, especially since recent research has helped disclose where we have our judicial courts. And these courts must exist if we have states admitted into this union, and if the Constitution remains in full force and effect as the supreme law of the land. Now, there are some of you out there that have a problem with that, and I don't disagree with it. But in effect, we've been taught for 230 years in good faith to believe in the Constitution, and I think we can get the job done doing that. But there are some serious things that you'll learn about further down the road. You don't want to start out with esoteric issues like these. I get most of them. But we want to teach you, and you get the 5 basic documents in my trial court packet, and you study those. You're going to learn a lot in a hurry. And then, by the way, with my materials, you get complimentary phone consultations, as much TLC via email as time and circumstances permit, complimentary updates on all documents for a year, and even a complimentary Zoom appearance in your case with a contested hearing. They can't let that happen. And they figured it out in South Carolina, by the way, in my felony case 6 years ago, and I was hauled across the country, got arrested in a library, which is hard to do. And it took 2 months to get from A to B, courtesy of 4 unmarked federal military aircraft. And when I finally get before the judge, who it looks like was actually one of the good ones, and there are a few around, they read the charges, and it turned out to be practicing law without a license, which is a felony in South Carolina, which I had never set foot, by the way, ever before this appearance I made. And I'm standing there manacled hand and foot in a red jail suit. I laughed. And I said, I don't practice law. I get it right the first time, just like it says on my business card these days. And then the judge says, well, we have to be sure that you're competent to represent yourself. And if I could have thrown up my hands, I would have. Betcha. Oh, a Beretta v. California, Judge 422 U.S. 806. The problem with that is that the U.S. Supreme Court ruled in Barron v. Baltimore 7 Peters 243 1828 the Bill of Rights doesn't apply to the states. Stunned the courtroom into silence. 30 seconds. It's $1 million video if I have it, which they claim not to have made. This in the court of record, by the way. But it was a great feeling when you realize the power we have. And I'm the one, as I said, manacled, hands and foot in a red jail suit. They're the ones in trouble with the law, and everyone knew it. And this in the cradle of states' rights, for crying out loud. You would think they would know it there, but boy, the knowledge even there is dead bang minimal. As they don't teach this stuff anymore in law schools or anywhere else. I mean, if I had learned some things in 10th grade U.S. history that you didn't learn, like the veto speech of Andrew Johnson on the Reconstruction Act of 1867, my life would have been considerably different, not only 50 odd years ago, but right outside of Washington, D.C., my hometown, wouldn't you know? Better late than never. So I have a lot of help I could offer here very reasonably, and then we can set them up for a big payday after we get through with them officially, one way or another, and go from there. It's a really great program I have laid out here, and we say it with attitude and with authority. I mean, if you're going to go into their courts and make a claim that there are no states remaining that were admitted into this union, Article 4, Section 3, you had better do it with attitude and with authority. On this subject alone, I have an unopposed 83-page brief on admission of new states, and you read, what they said about the admission of Maine and Missouri 200 years ago, the most important issue ever to come before Congress. And this at a time when you had people in both houses that were there when the document was founded and the nation set up, and they knew the original intent, and they talked a lot like it. Well, you see what you find today with Pansy Lenosi, Upchuck Schumer, Bitch McConnell. None of them has a clue. What looks like a two-party system isn't. It's a demo Republican party, and it has been for 100 years, if not longer than that. And you'll learn some simply astounding things by studying my materials and with my assistance. And by the way, I always ask the people to get my materials to give me a lot of feedback, so I can make it even easier for you to study and learn, and then make it easier for those that follow you so they can do the same thing. I use pretty plain, simple language, not a lot of legalese here and there. You'll see it occasionally, but not often, because just plain everyday language gets the point across. My goodness, no states, no elections, no electorate, no habeas corpus, no right to trial by jury, no right to an appeal, nothing. It's not there. And yet we haven't made any voluntary, knowing, and intelligent waiver of these rights, the Supreme Court reference standard. In that case, it's Johnson v. Zerbst, 304 U.S. 458. And you don't have to be near as good as I am, by the way. I can spout off this stuff. I mean, you get me on your case as a Zoom appearance as an expert witness, and you ask me the first question on Monday morning, we might get to the second question Tuesday afternoon. It's just the talent and ability that I have, and they can't have it on the record, and that's why they don't file your documents these days either. When I started out in another era, God, I'm going into my 40th year later this month. Can't believe I'm saying that. But we got documents filed, but at the time I didn't know how important that was, because what it does is sets the record officially, and every one of the issues that you'll learn how to use convicts them without more of treason to the Constitution. Not me saying it, the U.S. Supreme Court, and they know it. If they're acting without jurisdiction, they're not acting in any official capacity, and they don't even have qualified BS immunity, which they always argue under the BS civil rights actions that get filed. All you have to know about those is that 95% plus get tossed on the first motion to dismiss, and with prejudice, so you can't bring it again. I mean, it wasn't designed to work. It doesn't work, unless they have to make it look good. Think Rodney King here, for example. Once in a while, that does happen. But for the vast majority of people, especially pro se litigants, and you're not there pro se, by the way, we're there in propria persona. We're not acting as our own attorney. We've had no education in the schools to be able to do it. We haven't been to law school, which these days wouldn't help either. We are not there pro se. You'll have documents that state that to the black robe bastard, too clear to admit of doubt. And that black robe bastard, by the way, U.S. Supreme Court, saying it again, not me, is supposedly a neutral magistrate. When is the last time you saw anything like that on a case that you might happen to be in court? Whether that's traffic court, family law court, and that could be the worst, by the way. I'll be helping you deal with that one. They don't have any jurisdiction there either, or whatever court it is. And think about this, you walk into their courts and you can instinctively sense it, even if you didn't know before. I'm telling you now what's going on, is they think you're incompetent from the first moment. Now, I don't know if there's any factual foundation or legal basis to make a presumption like that. I sure as hell haven't found one. But think about what it means. If you're incompetent from the moment you set foot across the bar in their quote unquote courts, aka administrative tribunals, how can you possibly be competent on quote unquote election day? Oh, is that a problem or what? And there are no elections. I mean, even if there were, there are none. We don't have elections because if we can prove that we're in territories, and we can prove it, Congress has no authority in territories to make provisions for the election of the president, electoral college, anyone, voting members of the House, and United States Senator is still an appointed office by state legislatures, assuming that there are any states left. That's the power we have here to make these arguments on the record and in their faces. And they didn't know what to do because they didn't hear anything like this except for the elites, and maybe went to Starvard and Vail, and are going to be corporate lawyers for the New York banksters and might run into these issues, albeit unofficially, and have to know how to deal with them. And really, you can't. If we have the system we're supposed to have, and we have our right to trial by jury, and that's another thing, by the way, with my modestly priced constitutional defense document packets, you get almost 600 jury instructions. and that's likely being close to 700 by the time Easter rolls around. So I'll be adding to it. That's a time-consuming process, but I will be doing it. But almost 600, because we have the right to tell the jury our theory of the case and instruct them, and our jury has the power to rule on the facts and the law. That's where our remedy is. And that's what they can't stop. That's been true for 800 years since Magna Carta. And there's some esoteric arguments about that you're going to learn. I personally disagree with them, but I can see the basis for taking the position, going back 2 years prior to the Magna Carta, and but as I say, 813 AD. But that said, the trial by jury is a saving grace here. Now, I've never gotten to one. I'm never going to get to one. And I'm going to teach you how to demand yours. And there's no way you're going to get it, especially in a traffic court setting. I mean, think about that, because number one, they don't have a qualified juror pool at all. They're all 14th Amendment citizens, because that's what you have to declare under penalty of perjury you are. Amendment doesn't exist. Even if they did, it's going to take a couple of 3 days and maybe longer to select the jury, time that they don't have, courtrooms they don't have. And then we have to discuss the jury instructions themselves. And when you have almost 600 of them, unless the black robe bench is going to deny them at the stroke of a pen, like there's no right to trial by jury, which there isn't in their system, that could take another 3 or 4 days, and they don't have courtrooms for this. And I would suspect, even in the case of a quote unquote serious felony, you might get a sweetheart plea deal to get the thing over with. They simply can't, they don't have this much time and this many courtrooms. That's a lot of leverage for us. And I'm going to try to make it true in a family court, because I think there's every right to a trial by jury, even in that bizarre setting. And we'll talk more about that on an upcoming video. But that said, you can see where I'm going here. It's a lot of new material that you've never heard before. I didn't either. And trust me, I was at the head of the class with ignorance 50 odd years ago, when I went and volunteered into the U.S. Marine Corps at the height of the Tet Offensive. How stupid was that? And at the time, there was a lot of protest against the war going on, but I just didn't get it at that moment in time, in the 60s and early 70s. So I go volunteer, and my dearly beloved mom, who would be 101 now, put a curse on the Marine Corps and said, "You're not going to get them." And they didn't, because I walked into Fort Holabird, which is in Baltimore, on the way to Parris Island, and the sergeant looked up and said, "If you lose your glasses, how will you know who to shoot?" And you can see I'm pretty nearsighted, maybe even legally blind. And I didn't know the answer at the time. If I did know the answer, I would have said, "Fine, no problem. Give me an M16, send me back down, the Baltimore-Washington highway to the White House. I'll take care of the problem." And that is something of a joke, mind you, but it's Lyndon Johnson that got us all into this. And for those of you that don't know, I'm sure he was intimately involved in the events in Dealey Plaza. And even instinctively, I understood something was seriously wrong there. I didn't know what I know now at the age of 15, but that's his home political territory. He could not possibly have known this wasn't coming. And one of the first things this bastard does, and for those of you who don't know, November 22nd, 1963 was a Friday. Bastard gets in there Monday morning, and one of the first orders he issues reverses Kennedy's executive order taking us out of Vietnam. And that's what brought the war, quote unquote, UN peacekeeping effort, and years of wasted resources, lost lives. I mean, the whole thing. And we'll talk more about that subject matter later too, but trust me, we have so much leverage here when you know your rights and you know what you're doing. And it will take some time and study on your part. I'll be there. I'll have your backs. I answer a lot of questions, especially by email. But it's comparatively simple. And once it dawns on you, and the best part about this is you'll be leading by example for your children and your posterity to show them it can be done. And it can. That South Carolina case showed me that. And an Oakland case that I got a plea deal, and with a black kid, by the way. Here I am, a flaming white supremacist, quote unquote. And they were dismissive of me. I mean, condescending at the beginning. but they're the ones that didn't go to trial because they knew they couldn't have me on the witness stand as an expert witness, but they couldn't stop me. Time served plea deal. This is the kind of things that happens, and you can do plea deals. We might be discussing that later in your case, but always under duress and coercion, reserving all rights. It's the savings to students clause. Well, I've run on here, but I don't want to get too involved here. But do send me an email for information. youwinnincourt@gmail.com. I'll get right back to you. Meanwhile, subscribe, like the videos, tell your friends, get the word out. The sooner we start working together and cut out this divide and conquer BS they've been doing for at least 150 years, and get Asians, Americans, and Africans on the same page here, the quicker we get these bastards off our backs. Thank you.